tell you a couple of things about this program and about Neighborhood Legal Services. My name is Joe Olympi. I'm a managing attorney with Neighborhood Legal Services. I don't know how many of you have ever heard of Neighborhood Legal Services. We are a private nonprofit corporation. We're a law firm. We are not a part of the state, federal, or local government, although we're publicly funded. And what we do is we provide civil legal services to individuals at no charge who've got to qualify for our services based on income guidelines established by the government. But we do have special projects where we serve older adults, people 60 years and older. We get out to about 25 major senior centers here in Allegheny County once a month. You show up there for an appointment for the kinds of cases that we handle. We provide services at no charge, and we ask income questions, but we do not, there's basically no income guidelines for that special project. The reason we get out and do these older and wiser projects is we've been doing these for about 8 or 9 years. I think this is probably the 5th or 6th that we've done with Representative Smith's office. And the reason we do these is because we think these are good community education programs. They are topics that we get lots of questions about, and we know not just Representative Smith's office, but other offices of legislators get these same kinds of questions. So we've got about 6 or 7 topics. We've got 4 of them right now that we're doing, offering because we've sort of refurbished everything and updated it. And what we're going to talk about today are advanced directives, powers of attorney, living wills, and the last thing we'll talk about are do not resuscitate orders. We offer these to legislators. We don't charge to do these. Obviously, there's no charge to come in and see these things. We do them because we think they are good community education programs. We just we show up with the materials, somebody to talk, and it's the legislator's responsibility to find a place, get some refreshments, and just advertise this for us. Although we don't charge to do any of these things, we do like to acknowledge some of the folks that have given us funding to have this program. The H.J. Heinz Company Foundation has been pretty generous over the last 8 or 9 years with us. And this past year, we won an award from all places of the American College of Trial Lawyers. We're the recipient. This program, Older and Wiser, is a recipient of its Emil Gumpert Award, which is its most difficult award to get. And it came with a check to help us refurbish everything and update the materials and to expand the project. We already have people in a couple of other states who are interested in replicating this program. Mr. Dempsey is a lawyer who was to volunteer today to do this. I just spoke with him yesterday, and I'm sure something came up that prevented him from being here today. But fortunately, I'll fill in for him. I've been a lawyer for 32 years, and contrary to what some folks believe, those of us who work at Neighborhood Legal Services, we're real lawyers. You know, we don't just stay there until we learn how to be lawyers and get a real job. Of course, if you think that's true, you must be looking at me thinking I must be really dense because I've been here for a long time. But this particular seminar topic, I wrote this one, so this is an area that I'm familiar with. One last thing I want to tell you, kind of a housekeeping matter. You all got these handouts. One of them is a booklet that's in a question and answer format. It discusses some of the issues that we'll be talking about this afternoon. And there's 3 other documents inside. One of them is, this is probably the only form that I like, do-it-yourself form that we recommend to people. We're going to talk about this afternoon. There's this other thing called a do not resuscitate order. Some of them only have the SMP from the sample watermark on it, and the reason that's on there is because you can't fill these out yourself. You've got to get these from your doctor, and they've got to be signed by your doctor to say that you're eligible for them. Last thing we have is this. It's a survey. 8 questions, take you about 30 seconds to fill it out. We'd like to know, how we're doing, how you think we did, what you think we could do better. I don't need, your name or address, just if you give us the date. And the legislator, we'll know where that's from. We only want your name and address. If you say something bad, then we'll come look for you. No, I'm just kidding. I'm not serious about that. But I would appreciate if you just take 30 seconds, fill these out, and give them back to us because we do look at these. Okay. So let's get started with this thing. We're going to talk about 3 documents, and the first one we're going to just kind of give you an overview of the 3 things we're going to talk about, and These all come under the term of advance directives because they are directives or directions that we write out in advance of when we might need them. That's why they're called advance directives. And they are documents that instruct others or give them your instructions or your preferences and wishes in advance of some time when you might need them. And really, when you're writing those kinds of instructions down, you're setting forth your wishes, what you do, what you don't want to have done in advance of the time when you might not be able to express those wishes or preferences. That's why we call them advance directives. Sort of lets your family off the hook trying to guess what it is you wanted to do or didn't want to do. So what's the rush with these things? Well, nobody knows what's going to happen. I mean, I could, on the way out, I could be, hit by a bus or suffer some other misfortune. And, the best time to have done these documents, yesterday. Nobody knows what's going to happen or when something is going to happen in our lives that's going to make us unable to put these documents together and write our wishes down for what we do or don't want to have done. So the three things we're going to talk about are these things called power of attorney. This is a document where you authorize and name some other person that we call your agent to act on your behalf, to make your decisions when you get to that point in your life where you might not be able to make or communicate those decisions yourself. And we'll get into some detail about that shortly. The other thing we're going to talk about is a living will. And this is really a bad name for this document because most of us, when we think about wills, we think about documents that are going to be read after we've passed away. But a living will is a document that is meant to be looked at and referred to for your instructions when you are sort of in the end stages of your life and can't communicate your decisions, to find out what kind of special medical treatment you might or might not want. Bad name, but that's really, what everybody knows them about. Important things to remember here are there's a couple of points on the screen here. It says these things come into effect when you have an end-stage medical condition, or you've suffered some irreversible brain damage, or you've entered into a permanent unconscious state, a persistent vegetative state, or a coma from which you're not going to recover. These couple of terms are important to remember when you think about living will documents because an end-stage medical condition is some condition caused by, perhaps an accident or a disease, and the medical prognosis is that it is going to result in your death. The other thing you need to keep in mind is permanently unconscious. It's a total and irreversible loss of consciousness, a coma, something, condition where the medical prognosis is you are not going to come out of that condition. Last thing we'll talk about is should I consider any other kinds of advance directives. The only other thing that we talk to people about are these things called out-of-hospital do not resuscitate orders. Actually, I think the full name is out-of-hospital emergency do not resuscitate orders. And these are not the kind of do not resuscitate orders or DNRs that you might think about that are placed in a medical chart in a healthcare facility. It's very different. These are the kinds of documents that you have in place so that when the EMS people come, who come with the ambulance, the paramedics come, because perhaps you've fallen in your home and somebody hasn't seen you for a couple of days, or they find you lying on the street, they will know what your wishes are regarding CPR if they happen to find you. And you might wonder, how do they know I have these things? And we'll get into that when we get into the details section of this at the end. If you have any questions at any time, just put your hand up and I'll answer the questions as best I can. And if I don't, has anybody in here worked in a law office or used to be a lawyer? No, except Mr. Bowers. I ask that because then I can make up the answer and you'd never know the difference. I wouldn't do that really. If I don't know the answer, I'll tell you, or we'll get an answer for you. So what happens if you don't have these documents in place and you get to be in a state or a position in your life where you can no longer make or communicate decisions, not just regarding your health care, but about your finances, about what you want to do with your property, where you want to live, how you're going to spend your money? Here's some things that can happen. If you are in a position where you can't communicate or make your decisions and there's some question about your mental capacity, then somebody can file a petition with the appropriate court in the county system and ask that you be declared incapacitated and that a guardian be appointed to help to control you and to control your estate. Could be a family member, could be a social services agency, could be a neighbor. Anybody interested in your welfare can file these petitions. The other thing that might be in place if you get to be in that state in your life is a representative payee. Anybody ever heard of this term? Representative payee is something that we think about mostly with the Social Security Administration, and how that works is, you know, if your mom or your dad, or your brother, your sister, or somebody is at that point in their life where they can't make those decisions and they're getting Social Security checks, you go down to the Social Security Administration and you tell them and you provide some evidence from your PCP or the family physician that there's some problem, you can't handle your finances, and they will name you as a representative payee. And then those checks can be directed to your accounts or issued in your name, and then you have a responsibility to use those funds on that person's behalf. I mean, you can't go spend them yourself. You're supposed to use them for that person. Now, that representative payee could wind up being the same person as whoever might be appointed as your guardian. Doesn't have to be, but that could happen. So, and here's another thing. We're going to spend a little more time in this general area than some of the others. There's a thing in Pennsylvania now called a health care representative, and I'll bet that's not the best term if you ask me. When I think of a health care representative, I think of, you know, somebody who's going to come around with medical samples and try to sell you something. Most people probably haven't heard of this term, and to my surprise, many healthcare facilities aren't very familiar with this term. Now, a healthcare representative can make healthcare decisions for you, and this is important for a couple of reasons. We're talking about this because this is where we're discussing, so what happens if I don't have these advanced directives in place? So now in Pennsylvania, you know, you've got the guardians, somebody can be named a representative payee, but we also have these things called health care representatives, and this is pursuant to a law passed by the Pennsylvania legislature in late 2006, became effective near the end of January of 2007. And this might seem like another silly question. Can you name your own health care representative? Because we're thinking about an area where we're saying, well, you know, what happens if you haven't taken any action? And here's how this works. You know, if you happen to be like on your way to the hospital or being admitted to a hospital, and you might say when you get there, you know, I don't have a power of attorney in place, but I want my son or I want my daughter to make my health care decisions for me. That health care facility is supposed to designate and recognize that person as a health care representative. Now, excuse me, you can have more than one person named as a health care representative, just like you can name more than one person as your agent under a power of attorney, and we'll talk about that in a little bit as to why that might not be a good idea. Very quickly, it might not be a good idea to name two people to do things for you because, you know, if they disagree, one wants to do one thing, one wants to do something else, that could cause some problems. And we just mentioned this. So when does this thing come into play that a healthcare representative is named? Well, here's what has to take place. Your attending physician has to certify that you're incompetent or incapacitated, meaning that for whatever reason you no longer possess the ability to make or communicate your decisions. And that can be for a variety of reasons, and it might mean that, you know, maybe in most other areas of your life you're okay, but you're just not processing information correctly to make a reasonable decision, or a reason that might seem to be the same kind of a decision you would have made 20 or 30 years ago. So if you're certified as being incapacitated and there's no health care power of attorney out there, or maybe there is one, but that agent can't be found, or maybe the agent just says, I don't want to do this anymore. And agents can do that. They don't have to do these things for you. Or there's been no guardian of your person appointed to make health care decisions. So if these things are in place, you're incapacitated, and there's no power of attorney and an agent under that power of attorney to act for you, or no guardian, then healthcare facilities can start thinking about designating somebody as a healthcare representative. So, and this list, I mean, it's a lot of information on the screen here. This is right out of the statute. And healthcare representatives, healthcare facilities can look to this list as to who should be designated or recognized as the healthcare representative. And this list is right out of the statute. Take a look at that first one for just a second. It says your spouse, unless there's a divorce pending, and the adult children who aren't the children of the well spouse. You know, in a lot of situations that might not be very much fun to have that mixture of people trying to make decisions. It doesn't mean they all have to be recognized as the healthcare representative. You know, in that situation would be if it's a second marriage or you have children from a prior relationship. You know, the spouse could say to the stepchildren, you know, look, I've only been married to your dad for 5 years. You know, you've known your father all his life, all your life. I'm going to back off and you know, you make the decision. It can be just the opposite. The kids could say to the spouse, you guys have been married for 35 years. You know, you make those decisions. You know what mom or dad wants. Now, it also says the spouse, unless divorce is pending. And what that means is if one of you has filed a divorce complaint, and it doesn't have to be finalized or the divorce decree doesn't have to be entered. It just means if the complaint has been filed, that automatically kicks the spouse off that list. They're no longer able to be considered. So if you don't have the spouse and the kids up at the top of the list, then you just go right down that list to see who might be available to act as a healthcare representative. Healthcare representatives have pretty much the same authority as an agent that you might name under a healthcare power of attorney, except in very limited circumstances. There's just one or two things that they can't do, and it has to do with refusing to accept treatment if you're not in an end-stage medical condition. But that's it. They have pretty broad authority to act on your behalf under this statute. Now, when we sign powers of attorney documents, we know that the agents, the person that you name in a power of attorney to take care of your business, we call that person the agent, and you're the principal. Agents typically in most powers of attorney have got a piece of paper or an acknowledgement to sign, but under these things, they don't really usually require the healthcare representative to sign anything, but healthcare facilities can say, you know, we'd like to get a statement from you setting forth, you know, what facts you say are in place that give you the right to be the healthcare representative. And it's a declaration, which means in Pennsylvania, if they've told any falsehoods in that statement, they actually could be prosecuted for perjury. So what's wrong with having a guardian or a representative payee or a healthcare representative? A guardianship proceeding is very inconvenient. It can take a lot of time, and they can be pretty expensive. When you do a guardianship petition, what you do is you could do this yourself, I suppose, but it really is involved, and it's, you know, generally a good idea to get a lawyer to do these. You have to get a whole bunch of information together about the person that you claim is incapacitated. The petition requirements are very specific pieces of information need to be in there. You have to get that to the lawyer. The lawyer's got to prepare it. The lawyer's got to prepare some decrees that set hearing dates, and the lawyer's schedule's got to be coordinated with the court schedule, and sometimes it might take several days to get into court. Unless it's truly an emergency, you can get in pretty quickly. And guess what? You know, it's not cheap. One of our volunteers has said, you know, a lot of people think that paying $200 or $400 for a document or a set of documents is just too much money. You know, we don't want to do these advance directives. That's just too costly. And his take on it was, you know, if you don't want to do that, that's fine, as long as I know you're going to come back to me. The family's going to come back to me when it's time to do a guardianship hearing, and you're going to pay me $3 or $4 or $5 or $6,000 to do that case. That's not a bad deal for the lawyer. These things are very expensive. The way you prove that you're paying for the lawyer's time to do this, and the way you prove somebody's incapacitated, is you provide medical evidence. And the way we provide medical evidence typically is we take the doctor's deposition rather than have them come to court. And to take a deposition, you have to have the doctor there, you know, the lawyer's there, the lawyer representing the person who's supposed to be incapacitated is there. They're both charging. The doctor's going to charge to sit for the deposition. And guess what? The court reporter that shows up, the stenographer, they're going to charge you $35 to $50 just to show up. And then you're going to pay anywhere from $1.50 to $2 or more for every page of written transcript that you're provided with the doctor's testimony. It gets very expensive. The person who gets appointed as your guardian, if you're really incapacitated and can't express your wishes, might not be the person who you would have chosen to take care of your affairs for you, which is just another point as to why it's important to do these things ahead of time, because you can make that decision. And again, I mean, really what you're doing by putting these documents in place is you're making sure that your family doesn't have to guess what you do or don't want to do. It's taking the guesswork out of it. They don't have to substitute their judgment for yours, and they know what you do or don't want to do. And we've already said these are legal documents, and again, the person that you name to take care of your affairs, that's the agent. And you as a person who names that individual, you're called the principal. And sometimes we hear these things, these terms, a power of attorney, agent, and attorney in fact are all used interchangeably. You know, yes?
Does durable power of attorney also fall into that category?
No. Durable power of attorney, we're going to talk about that in a few slides. There's actually a lot of misconception about what's meant by a durable power of attorney. But we're going to talk about that in just a few minutes. When people say, sometimes people refer to the agent as the power of attorney, and that's not technically correct. You know, we all know what that means. Up until about 12 years ago in the law, that person was identified as the attorney in fact, and since 1999 they've changed that term to agent, which probably makes a little more sense to most people. So the power of attorney, if it's well drafted and it's pretty inclusive and it's got everything in that you might need to have somebody have permission-wise to make decisions for you, it's going to eliminate the delays and the expenses of petitioning to have a guardianship established, and it's going to make sure that somebody can take care of your stuff for you, the person that you want it to. You can have an agent do all of these things that are listed on the screen. They can arrange for your care, your protection. They can take care of your financial responsibilities, although it's important to note that an agent is not required to assume personal financial responsibility for any of your bills. They can if they want to, but there's no obligation that they use their own assets to pay your bills. Their responsibility is to prudently manage your assets and to use your assets to take care of your responsibilities. They can do all kinds of things, manage your investments, manage property. There's a lot of reasons you can have a power of attorney in place. One of them is you might want to name somebody who is going to take care of some things for you for maybe 4, 5, 6 months if you're maybe out of state doing something, and they can be told that they're doing it for a very limited purpose. You know, you can have access to my checking account to pay my utility bills, my property taxes, and that's it. October 31st, 2011, it's done. Very limited purpose. But when we think about these as kind of long-range planning tools, we're not talking about something that's got a limited purpose or a limited duration. We want something that's going to be in place so somebody can actually take over for you when you're not able to. This is a really important set of statements here, and this is the most important decision that you make when you do a power of attorney. And that decision is who you're going to name as your agent. It better be somebody that you trust. Somebody who knows you, knows your preferences or values. Ideally, maybe they act responsibly under stress. Maybe they've had some prior experience doing this. I've just seen too many cases where people have not given a lot of thought to who they've named as the agent, and they've named people who have stolen their money. And some people have had lots of money stolen. And, 9 times out of 10, in my experience, while you may have a great case to sue that person and to get a judgment against them to get that money back, actually getting any cash back into your hands is oftentimes much more difficult. So it's important to make this decision up front. Make sure that it's somebody that you trust. The lawyer you go see is not going to know that. A limited power of attorney. We talked about that before. Just for a limited purpose, do just a couple little things for me. Banks use limited power of attorney forms. If you want to have somebody authorized to access your account, that's essentially a power of attorney form for a very limited purpose. But that's not really the kind of documents we're talking about today. We're talking about something that's a general power of attorney. So how long do these things last? Well, you can decide. You can limit their duration, or for the unlimited period, the durable power of attorney. Now, the word durable means this. It just means that that power of attorney document remains in effect or comes into effect when you get to be disabled or incapacitated. That's all that means. A lot of people think that a durable power of attorney means health care, but it doesn't. And it's kind of an odd word to see in a power of attorney nowadays for this reason. About 20 years ago, if you wanted to have a power of attorney be a durable power of attorney, meaning that it lasts after you get to be incapacitated or comes into effect when you're incapacitated, which is really the important time for it, you had to have special words in the document. You had to say, I don't intend this to be affected by my disability or incapacity, or I want this to come into effect when I get to be disabled or incapacitated. If you didn't have those words in the document, it wasn't durable. Well, that changed in December of 1992. Pennsylvania legislature changed the law, and it said, from this point forward, every power of attorney done in Pennsylvania, executed, is automatically presumed to be durable unless you say otherwise. So nowadays, they're all durable unless you, for some reason, want to limit it for something, for some set of circumstances. Now, powers of attorney can also be revoked automatically in some circumstances, and those circumstances are, again, if your spouse has filed the spouse that you've named as an agent, if one of you has filed a divorce complaint, that power of attorney is automatically revoked. Now, in a power of attorney document, you can say, I've named my spouse, my wife, to be my agent, and I don't care if she files a divorce complaint to dissolve our marriage, or if I file one, I trust her. I want her to make my decisions anyway. Is that a good idea? I don't know. Maybe not. I'm sure there are many marriages that dissolve amicably and people remain friends for the rest of their lives. Of course, they're not the ones lawyers hear about. Maybe it'd be a good idea, maybe not, but that's something that you can do. And again, these things are preferred, the durable general power of attorney, because they stay in effect after you're disabled or incapacitated, which is really when you need them. And they last for a long time, and they give your agents a very broad authority to do anything that might need to be done for you. On power of attorney documents now, for about the last 12 years, you've had to have these two forms on them. The notice form and the acknowledgement form. Now, at the bottom of the screen, you see that note that says, if it's only a health care power of attorney, you don't need these two forms. And here's why. These two forms are basically, thank you, Judy, very much. These two forms are basically where the notice form says, and it's got to be in the same format as is in the statute, or substantially like it. It's got to be in all capital letters. It's got to be the first page of the power of attorney. And it says something like this. I mean, it really is an entire page, but it says, I'm aware that by signing this power of attorney, I'm authorizing my agent to make important decisions regarding my assets. They might be able to have authority to sign property, to make loans on my behalf, take mortgages on my property. And I've read this and I understand it, or I've had it read to me and explained to me by my lawyer. And then you've got to sign it and date it on the bottom. The other thing is an acknowledgement form, and that's a very short form, and it's a form that your agent is required to sign that says, basically, I'm not going to cheat you. I'm not going to commingle your funds with mine. I'm going to do the right thing. I'm going to use your money for what your needs are. And they're required to sign that document. And these things have got to be attached to a power of attorney to make it valid, unless, of course, it's just a healthcare power of attorney. So what causes these things to come into effect? Well, a couple of ways these things can be put together. We have this thing called a springing power of attorney. And some people say, I'm signing this power of attorney and I'm not really comfortable with giving it to my agent, whether it's your son or your daughter, whoever it is. While I'm okay, I don't feel comfortable with that. I can make my own decision. So you can put language in a document that says, I don't want this to come into effect until I get to be disabled or incapacitated. And here's how you figure that out. You give some instructions to your agent. You tell them that they have your authority to talk to your treating physician, your PCP, or your psychiatrist, and give them access to your medical records for the purpose of determining whether or not those physicians think that you're incapacitated, and to get a statement from them, attach it to the power of attorney document as proof that it's now in effect. That's a little unwieldy and might take some time to figure that out, but that's how that works. Now, the other way some people do it is they'll do these things called a non-springing power of attorney, and that document is in effect when you sign it, and when your agent has signed the acknowledgement, if your agent is going to be dealing with your finances. And here's what some lawyers do. If they have an appropriate facility to store those documents securely, they tell the family this. We know that our client, the principal, your mom or dad, doesn't want this released because they don't feel comfortable. They can make their own decision. So we're going to keep that original document. We will keep it, and when you think that mom or dad is incapacitated, you come back and see us, and we will help you make that decision. If we have to get an evaluation done, we'll help do that. And if we think that we're satisfied that they are incapacitated, we'll release the document to you. So that's how some people do that. A couple of things about the powers of attorney. If they're documents that have health care provisions in them, they have to be witnessed by two adults. They don't have to be notarized in all cases, but I think it's a better practice to have them notarized. And it really should guarantee your agent access to your medical records. These documents have got to be notarized if they are going to be used to do anything with real estate that you own. And the reason they've got to be notarized is because then they'll have to be recorded at the Recorder of Deeds office. Yes, Lauren?
It may be important to know that our office can witness and notarize anything free of charge. So we want
Oh, that is good to know.
they can contact us. You know, if you want to repeat that so it gets picked up by them.
Yeah. I've just been informed that Representative Smith's office will witness and notarize documents free of charge. So that might be helpful to have that available. So what do you do with these things after you have them signed? You got to give a copy to your agent if he or she's supposed to be using it now. Keep it someplace with your important papers, the original. And last but not least, you should go to your bank. And why do I suggest that? Well, I'll tell you a quick story about this. Anybody here work for a bank or used to work for a bank? Oh, geez. Okay. Banks don't like power of attorney documents that have been prepared by lawyers. I'm not sure why that is, but they just don't like you to walk into a branch office and say, my father appointed me as my agent and I want to get my name on that checking account. About 5 or 6 years ago, I had a friend who worked in the court system who called me, and she said, could you come out and see my father? He's been diagnosed with cancer, but the prognosis was not bad. I mean, he had, several years that they indicated. He said he'd like to talk to you about a will, a power of attorney, and a living will. So I said, sure. I went out to see this fellow. He was in good shape. He was able to discuss everything with me. I was convinced he had capacity to sign these documents, so I took my notes, went to my office, prepared the documents, sent the draft to him to take a look at, and to the daughter, my friend. Called me back and they said, okay, that looks fine, and we made arrangements to go out, went out to his house, he signed them, he was still in good shape, no problem. Took them back with me, put everything together, mailed them back to my client and to the daughter. And about a week later, the daughter called me, of course, when all emergencies occur, 3 o'clock on a Friday afternoon, and she was crying. And she said, I said, well, what's wrong? She said, well, that power of attorney you did for me is no good. I said, well, what's the problem? She said, well, something happened to my father. He is now basically in a coma. He's taken a turn for the worse. So nobody knows what happened. And there was something he wanted me to do at the house, and I needed to get some money out of the checking account to do this stuff. Went down to the bank with that power of attorney, and the branch manager at the bank said, oh, that's no good. He'll have to come down here and sign our signature cards to get you onto the account. To which, of course, she said, well, he's in a coma. He can't do that. So fortunately, she was able to find me, and in about 40 minutes, I was on the phone with somebody from that bank's legal department who was pretty appalled at what my friend had been told. And I was able to do a cover letter and a copy of the power of attorney document to the legal department, and in about an hour, they had called the branch and said, there's nothing wrong with the power of attorney, it's okay. Give this person access to the account, because obviously the man couldn't come down to sign a signature card. So I'm not telling you that story, to show you how wonderful I am. The point of that story is, go down and have this conversation with the bank now before it's, at the 11th hour. Get that straightened out now. It's just important to have them know that that document and give them whatever information they think might be necessary. Get it over with now while everybody's okay. We've talked about these 2 points, but the last thing is, and here's an area of big misunderstanding, you can only sign a power of attorney if you have the capacity to understand what you're doing by signing that document. You don't have to understand every single word or the legal nuances of all the paragraphs in the documents, but you have to understand that you are authorizing some other person to have access to your finances, to your personal information, your medical records, and to make decisions on your behalf in all of those areas. You have to understand that. If you don't understand those things and you're already incapacitated, we can't have you sign one of these documents. It's too late. Let me mention one other point about the capacity to sign these documents. Lauren just asked me a question, and when I say that you've got to have the capacity to sign the document, to understand what you're doing, that just means, I'm talking about your mental capacity to do that. Power of attorney documents, just like almost every other document I can think of, can be signed for you and put into place even if you are physically unable to sign your name, even if you're unable to make an X. There are ways that those documents can be put in place for people. Somebody else, if you're able to understand the document and indicate that you understood it and agree to it, somebody else can actually sign your name to the document, and there are provisions for that in the statutes, and that's recognized as a legal document. We're going to look at the living will documents right now. And actually, even though we look at these in 2 different parts, powers of attorney and living wills, particularly since the statute was amended a couple of years ago, most lawyers, if they're going to do a power of attorney document and a living will, they're generally combined into one document nowadays. You just have, part 1 might be a power of attorney. Maybe it could be a power of attorney for just finances. And then you could have a power of attorney for health care. And some people do that. They might want to name, their son to take care of the finances, the daughter to take care of the health care decisions. You can name two different agents for different reasons, or you can name the same person to do everything. It's really a personal choice. And then the last part of those documents could be the living will, which is a little bit different than a power of attorney. So how do these things protect you? Well, for all the same reasons that a power of attorney would. And this is a little more serious than you might think of as the health care provisions in a power of attorney, because, again, a living will is a document that's going to be looked at for your instructions when you have an end-stage medical condition and health care facilities are talking about or talking with your family about what kind of life-sustaining medical treatment you might want. And we're going to talk about that in a few minutes. Some confusion. Again, this is another document where, living wills is not the best term. Some people confuse, last wills and living wills. And crudely put, a last will, it's a document that says who gets your stuff when you're dead. And you name an executor to make sure those instructions are carried out. A living will is a document that contains medical instructions, or your instructions regarding what medical procedures you do or don't want before you die. So they're two very different documents, but oftentimes confused. In these documents, you can have instructions for not just what life-sustaining medical treatment you might want, but that you might want treatment for comfort or to alleviate pain. You might have instructions about whether you want CPR. And the last thing here, life-prolonging procedures. And life-prolonging or life-sustaining medical treatment are treatments that are recognized in the statute, and the law says this, that these are medical treatments that when they are administered to you, they're not going to cure your condition, they're not going to bring you out of a coma, they're not going to, usually change the prognosis that you're going to die. They are medical procedures that are going to stretch out the point when you'll pass away. That's what life-sustaining medical treatments are. Now, in a living will, there's some other instructions. You can say, look, if I have some kind of irreversible brain damage or disease, I want to be treated just the same as if I'm in an end-stage medical condition, and follow my directions if I'm in that condition. And you can also tell your agent, look, I put a lot of thought into this stuff. My instructions are written down, and I want you to follow them verbatim, exactly as I have them written down. Or you could say, you know me pretty well, and if you want to get off the path here that I've indicated in the document, you don't have to stick to them exactly. You can make some other decisions if you like. If you're going to do that with somebody, that better be a person who you think knows what your preferences and your values are and what decision you would make. In these living will documents, a lot of people say that, they're afraid of what happens if somebody sues me if we follow the instructions of the living will. And the law in Pennsylvania says that you don't have any liability as an agent or as a healthcare provider for following the instructions that are set forth in a valid living will. And does that mean that nobody's ever going to sue you if you're an agent? Well, probably not. I mean, people sue all the time, even though they don't really have any valid basis. If somebody would sue you because of your instructions, the instructions that you made sure were carried out as an agent, I mean, this law is a defense to any liability.
Can I ask a question?
Sure.
How did they have access to these living wills in a timely manner when you were, in these situations of medical treatment? To actually make these decisions, say you become unconscious and you're hospitalized, and I'm curious about that. How does that happen in a timely manner? Maybe that's beyond your expertise. But.
No, I know everything, just about. I'm just no. No, the question is, how do you know, as a healthcare provider, that these things are in place in a timely fashion? Well, a couple of ways you can know that. There are one of these forms that we're going to talk about in about 15 minutes. It's got a little card in the back that you can cut out and says, I have a living will. doesn't have the entire contents of the living will on there. But what's important to keep in mind about living will documents is they provide authority not only to withhold life-sustaining treatment, meaning I don't want to be put on that stuff, but if for some reason the existence of that living will document is not known when you're rushed into an emergency room or, found at home and they take you to the hospital, living wills also provide statutory authority for your agent to withdraw you from life-sustaining medical treatment. So if for some reason they don't know that you have a living will and you are put on life-sustaining medical treatment, whether it's mechanical resuscitation or whatever, that document is authority to withdraw you from that treatment.
And related to that, ask a secondary question.
Sure.
If you're in another country, do you then need to, take a copy of your will to the consulate?
That I don't know the answer to. And write that down. When's the last time you heard a lawyer say, I don't know the answer to that?
I probably, if you don't know the answer to that, I think I would just probably do that.
Yeah, I would say this. I don't really know what you do in other countries. Probably having a copy of it with you is not a bad idea.
You can have it with you all the time.
Right. I mean, if you travel, you maybe take a copy. Traveling in the United States, I would say that, when laws like this get passed now, that deal with either power of attorney documents or advanced directives, which is what both living wills and powers of attorney are, a lot of times they're based on model legislation. And Pennsylvania's statute says this about documents from other states. It says, if it substantially comports with the requirements in our statute, it should be recognized. And I think several other states have similar provisions in their laws. If you're traveling out of the country, I think it would be a good idea to have the document with you. As to whether it would be honored, I honestly don't know the answer to that. Yes?
My experience has been, the minute you walk in the hospital, the second question they ask you is, do you have a living will?
Right.
That comes right after you have insurance.
That's true. And we'll talk about that. Now we have a slide on that in a bit, but since 1991, healthcare facilities have been required to ask you if you, well, they don't even have to ask you, they're required to tell you that you can have one.
File here at this hospital. They want to know that too.
Well, here's the other thing about that. If you're going to be admitted to a healthcare facility, they are going to ask you if you have a living will or a power of attorney. We always tell people, even if you've been in that hospital, 3 months or 6 months ago, take another copy with you, because some healthcare facilities, I understand, when you're discharged, they take those documents out of your records because, which didn't make much sense to me at first, but I think they've done that because, well, they don't know if you've done a different one, would possibly eliminate some confusion. But here's another thing to keep in mind. If you go to a healthcare facility and during the admission process they say, do you have a living will? You say, yes, but I don't have the copy with me, it's at home, and they hand you another one to sign. I don't normally think that's a good idea, because by signing that second one, you may have effectively revoked the first one, and maybe you had some special provisions in that one that maybe a lawyer helped you draft it, or you had more time to sit down and think about it. So I don't normally think it's a good idea to, if you have one, just say, we'll get a copy. They can't make you produce one as a condition of being admitted or being treated.
Along that same lines, is there a central registry being considered with all these going to be on file someday?
The question is there a central registry being considered for these things? I haven't heard of that, but I would be surprised if that is going to happen for a number of reasons. I think, well, currently, I don't think that's going to happen in Pennsylvania, because that would require the creation of a new office and more staffing and more overhead. I don't think that's going to happen. The other thing is that, you generally don't need to produce an original of these things. So, you can have if you have a smartphone that you travel with, you could have a copy of it on a smartphone. I mean, smartphones can access email, can access, server documents. Be a good idea maybe to store them in a place like that. Some documents you can record for sort of safekeeping, but a living will and actually a last will is not a document in Pennsylvania that you can currently record any place for safekeeping in any public office. You can record a power of attorney. And in Allegheny County, you can record a power of attorney for a couple of reasons. If you have a power of attorney where you've given your agent authority to deal with real estate, to take a mortgage in the house, to sell the property, that power of attorney, again, as we said before, has got to be notarized. There's got to be a special acknowledgement on it. And it has to be recorded. And if it's being recorded for the purpose because your agent is going to sell real estate, it gets recorded in Allegheny County at the Recorder of Deeds office. And it's because if I have a power of attorney that I've given to my daughter and she's going to sell my house, anybody who's going to do a title search would want to see that document as part of the public record to know that she has permission to sell that property. It makes for a good chain of title. If you have a power of attorney that you want to record for safekeeping, you can do that in Pennsylvania. And in Allegheny County, if you want to record it just so it's recorded someplace and you can get a copy if you need it, you would take that to the Orphans Court or the Register of Wills office. I think it might be the Orphans Court office to record them in Allegheny County. It varies on counties where you take them. And they record those just like they record a deed. They take a picture of it, they index it, they give it a number, and give you the original back. And of course it costs to get them recorded, but the recording does two things. Then your power of attorney document is a matter of public record. Anybody can go take a look at it. Personally, I don't really care if anybody would see a power of attorney that I would have, in effect, for myself. But if the original document is ever accidentally destroyed or lost, you can go down to that recording office where you recorded it and get a certified copy from their records for literally, $3 or $4 or $5. And that's recognized as good as the original in Pennsylvania. And sometimes that's a good idea because some people do lose those things or destroy them accidentally. And then, mom or dad or whoever it is that signed over that power of attorney, maybe they don't have their capacity any longer and can't sign a new one. So it might be important to be able to get it in that sense. Now, you can't do that with a last will or a living will anywhere in Pennsylvania. Now, of course, if your living will is part of your power of attorney document, then it would be recorded if you're going to record the power of attorney. And the living wills nowadays, the form that's in the statute has places for you to sign it, witnessed by 2 adults, and they don't have to be notarized, but we notarize all the living wills that we do for people. People like to see the embossed seal on the living will, or on the notarization stuff. Where the notary takes they stamp it. You ever see those seals on affidavits? Well, did you know that since 2005, notaries don't have to use that anymore? They're not required to use it for notarization. They just have to have their rubber stamp on it that says, here's who I am, here's where my office is, and my commission expires. But we use them anyway. And people like to see them, and it kind of makes it easier to tell the originals. So who can sign these documents? Well, anybody now who's 18 or married or a high school graduate or an emancipated minor can sign these documents. You don't have to be all 4 of those things. Any one of those will do. And they have to be witnessed by 2 adult witnesses now in Pennsylvania. When does a living will come into effect? When it's been signed, when your attending or treating physician has a copy. They don't have to see the original. And most importantly, when the person who has signed the document is determined to be incompetent or incapacitated, and they have an end-stage medical condition, or they're permanently unconscious. If you don't meet those 2 qualifiers, then they shouldn't be looking at your living will deciding what you want to do. They should be asking you and discussing it with you.
Excuse me,
Yes?
about the attending physician having a copy, do you file that with the physician at the time that you create the document?
We generally recommend that if you've got a PCP or an attending physician, not attending, but a treating physician that you've been dealing with, they should have a copy of it. The attending physician will be in the hospital. That should be a part of the medical records in that facility. There used to be, in Pennsylvania law, one instance when a doctor had to see the original. And guess when that was? When you were taken to the emergency room, which would seem like the time when you'd be least likely to have it. But there were other ways they could have verified it then, but they changed that not long after it was passed, actually. So what do you do with these things? Some people suggest signing several as originals. You know, sometimes we do that if there are a lot of people to give them to. You ought to give a copy to your agent, one to your physician, and as I said before, bring a copy with you even if you've been admitted to that facility previously.
So, excuse me, to clarify, is there only one valid original, or can you make photocopies of these?
You can make photocopies of them. You should never give the original up. You know, don't ever, I don't ever recommend giving the original. A copy is sufficient. And again, they can't make you sign these things as a condition of admission. They're just required to tell you that these are available to you in your state. We talked about combined documents, and if you look at this document that's on the slide, that's actually the cover of the document that was in the booklet. This one. This is, you know, probably the only do-it-yourself form that I've seen that I like. This document was put together by the Allegheny County Bar Association working in conjunction with the Allegheny County Medical Society. And the reason I like this is if you look at the first 6 or 7 pages, it's put together in a question and answer format that is designed to help you fill out the blanks in the rest of the document. This document has been revised since the law was changed in 2006. But if you look at this document and the one that was prior to this one and compare it to the form that is right in the statute, it's pretty evident that the legislature used this form as the basis for the one that's contained in the statute. So I think it's a pretty well-regarded form around the state. Now, this document happens to be a living will as well as a health care power of attorney. You can combine those two, and if you can also put finances in one too. You know, you can combine those documents into one. And really, the reason we tell people that these are good ideas is, you know, you're putting down your instructions before anybody needs to know what they are, so that you're taking the guesswork out of what you do or don't want to have done. And you're also eliminating the possibility that somebody will substitute their judgment for yours. You know, if somebody might look at me, if something happened to me, I might, if I were able to express my wishes, I might think, you know, I don't want to live like this. I don't think this is the best condition, and I would choose not to have any treatment. But somebody who perhaps doesn't know me, who might be in a position of making that decision, they might say, well, I think we should do what's in Joe's best interests. And what somebody might think is in your best interests might not be the decision you would make. So, and when we don't know what your instructions are, you're obligated to do what are in your best interest, in that person's best interest. That's why it's so important to have your instructions and your wishes stated in these documents. We don't have to guess. Healthcare power of attorney agent, an agent just like an agent you name under any other power of attorney. They have authority to make your decisions, and if it's a living will document, they are also going to be able to make decisions about life-sustaining medical treatments. And you name that person so that, in addition to setting forth your wishes, it's the agent's job, should they choose to accept it, to make sure those instructions are carried out. Now, can you name anybody as a healthcare power of attorney agent. You can name anybody you want except your attending physician or a healthcare provider that are currently providing care to you. You can't name them unless they're related to you. Then you can. You can name an emancipated minor as your agent. Is that a good idea? I don't know. I guess that's your decision. Maybe you know a incredibly mature 16-year-old who you'd feel comfortable making those decisions. Yes?
Will you please define
An emancipated minor is somebody who is under the age of 18, who's no longer legally dependent upon their parents or their guardians for their support. They're living out independently and on their own. And you can, just like you can in a power of attorney document for any other reason, you can name more than one healthcare agent. So under the statute now in Pennsylvania, this looked terribly daunting to me when I read this. This is about 3/4 of a page in very small print in the statute, which I've paraphrased. And if you look at it, it really just makes, it's common sense. These are the things that an agent is required to do. Gather information, the prognosis, diagnosis, treat. Well, certainly you'd want somebody who is your agent. I mean, anybody with any degree of common sense, and of course we would always appoint somebody with common sense as our agent, right? This is what they would do. If I were going to make a decision on behalf of somebody else, of course I'd talk with the doctor. I want to know what the diagnosis is, what the prognosis is, alternative treatments, anything else that can be done. It just really makes sense. Now, healthcare agents can do virtually anything on your behalf that you could do if you were able to make and communicate a decision. There's something in the middle here. They can also make anatomical gifts, dispose of your remains, and consent to an autopsy. Now, they don't have to do that. You don't have to give them that permission. You can say, I don't want my agent to be able to consent to these things. I'm not granting that permission. Now, if it's just a health care power of attorney, that agent probably would not have authority to handle your finances or your estate. So it's important to remember that. If you are thinking of naming somebody as your health care agent just to make those decisions, it's important to, finish up that job and name somebody to take care of your finances. Same rule as when you're picking an agent under a power of attorney, a regular power of attorney. You got to pick somebody who's going to follow your instructions, get their consent, and let them know when that document has been signed. You really need to get their consent. I don't want to call at 3 o'clock in the morning saying, Mr. Olympi, we found your Aunt Betty on the street in Allentown, Pennsylvania, and we think she's dead, she's brain dead, but we have her on a life support system, and we found her living will, and you're her agent. What do you want to do? I don't want that to be the first time that I've learned about that. If you talk about these things with people, some people don't want that responsibility. They'll say, I don't want to do that. Ask my brother or my sister, or ask your sister. I don't feel comfortable making those decisions. So you don't want to name somebody and then find out later on that they don't want to do it, because there's no legal obligation that they actually act as your agent. Even if you've named them, they can say, nope, not comfortable, don't want to do it. Yes?
Say you're in a situation where you choose your spouse, and there's a car accident. Is it wise and is it possible then to choose an alternate and to list that?
Yes. The question is choosing an alternate or a substitute. And that was one of the last things that we talk about with these, not just in a healthcare power of attorney or a living will, but in any kind of a power of attorney. I don't usually think it's a good idea to name more than one agent, unless there's some really compelling circumstances to do that. If you name two people and they each want to do something different, then you're at a deadlock. I generally think it's a better idea to name your first choice, and then somewhere else in the document say, if my son is, something happens to him, if he predeceases me, or if he's unable, to carry out these responsibilities for whatever reason, here's how, you determine if he's alive, somebody can certify that he's dead. I then want, my daughter to step in and be the agent for me with all the same powers and responsibilities assigned before.
So you can state it, but you state it clearly.
Yes, you have somebody that your first choice and then an alternate or a substitute. Yes, Lauren.
If you had multiple children and you wanted them both to be listed, would they have to be in agreement? Or if one says one thing, that's what happens, even if the other one, is it, either vote? How would that work if you did have to?
Yeah, well, that's a good question. That really sort of dovetails into why I don't like do-it-yourself forms, and here's why. You can name 3 or 4 people to be your agent and to have them all, act at the same time. I guess if I had a preference, I would choose an odd number because then it's less likely that you're going to have a deadlock. If you've named multiple agents to act at the same time and 2 of them want to do one thing and 2 want to do the other, I'd say that's a deadlock and you're going to wind up, having to see a lawyer and then who knows, maybe even get into court to get that resolved. But here's something about forms that most people wouldn't know this stuff, and I haven't seen a form that addresses this. You can go on the internet and find a form to do a power of attorney. And I've seen people who've come in, to my office through various means, who their moms or dads had done that, or they had done it. And these forms are just too often don't do what people think they're doing. And here's one of the main reasons that they can get fouled up. In Pennsylvania, if you name multiple agents, you can say, I'm so-and-so, I live here, and I am naming and authorizing, my son and my daughter to be my true and lawful agents to act in the following areas for me. Well, guess what you've done? Well, kind of. Well, what you've done is, in addition to that, you have named them to act as joint agents. Now, what does that mean? Well, that's a legal term, and by naming them as joint agents, that means that they each have to be together to do everything you've authorized them to do. One can't do it without the other. Now, any lawyer that drafts these documents would know that if that's not the intended result, we would have language in there that says, I'm naming my son and my daughter or daughters to act severally as my agents. Severally means that any one of them can do any of the things you've set forth in that document without having the others present. Now, does that have some drawbacks? Yes. What if they're all out doing something different and they don't communicate well? That could cause some confusion. But when people do forms and see that kind of, they wouldn't know that. Lawyers would know that stuff. And if you took the time to read the statute, you'd be able to figure that out. But that's just one of the reasons I don't like. I've seen too many power of attorney documents attached to guardianship petitions that have been filed in court because the power of attorney documents have just not done what people thought they were going to do. So, naming agents, you can name more than one. Sometimes it's a good idea, sometimes it's not. I can only think of one circumstance where I was really convinced that I should name 2 agents for my client. My client was about 97 or 98 years old, but just, remarkably good capacity. And she just browbeat me into submission, into naming both of her sons as her agents, and rather than choosing one as an alternate and one as the first choice. And this, I was a lot younger then, and this didn't occur to me. But I said, that might not be a good idea. It's probably better to name one as your first choice and the second as an alternate. And she just looked at me and she said, I'm 98 years old, don't you? And I said, yes. She said, well, how old do you think my sons are? And she told me that they were, like 78 or 79 years old. And she said, and they both have heart conditions. One of them could drop dead before me like tomorrow. So they didn't want to have to go through that. And thought that was a good idea. I said, okay, you've convinced me. So sometimes there might be some good reasons to do that. Yes.
My mother had the same situation with, I have 3 siblings. She named me as the primary, and then contingent DOAs on down the line, in case I kicked the bucket, next one in line would take over, so on down the
Right.
line.
Yeah, and I think that's the better way to do it. I think that just kind of eliminates some confusion. What should be in a healthcare power of attorney? Well, obviously, it should identify you. You should indicate that you're authorizing your agent to make healthcare decisions. You can put some limitations on what you want them to do or don't want them to do. You can also tell them, you know, look, I don't want any other life-sustaining procedure, medical procedure, but I do want nutrition and hydration. Or maybe I don't want nutrition, but I do want the water. Because, there's been a lot of stuff written about, how that might be to pass away not having those particular treatments. Your agents can make, obviously they're making decisions if you're incapacitated, and they can also take legal action on your behalf to make sure your instructions are followed out. We also generally have some language in these things where we spend a whole paragraph talking about the HIPAA privacy rule. You've all heard of that. We have a language in the documents that I do that says, I'm giving my agent access to my medical records, notwithstanding any provisions of the HIPAA privacy rule, and we cite where the statute is and where the regulations are and then all that. And the reason we do that, you don't have to have that in there to get around HIPAA. But it's easier to have that in there so healthcare facilities can see it rather than to have lawyers call them up and explain why it doesn't have to be in there. If you actually read the HIPAA privacy rule, the HIPAA privacy rule says personal representatives, even under the HIPAA privacy rule, have access to your medical records and information, and they define personal representatives as agents under a power of attorney or a guardian. But it's easier just to put it in there, eliminates a couple of phone calls. There's another question, too. Can you change a power of attorney or a living will? And the answer is yes, provided that you still have the mental capacity to know what you're doing by changing it or revoking it. You can change it any time. If you're going to change it, it's a good idea to give all concerned parties new copies, and you can revoke them. If you don't like the job your agent is doing, you can fire your agent. Unfortunately, I've seen many circumstances where, and it's usually my clients' kids where this happens with, they think that as soon as mom or dad signs that power of attorney, that is a legally binding declaration that mom or dad is completely crazy and I'll do whatever I want. I'll step in and manage things. I don't care what mom or dad wants. And that's not true. As long as you retain your capacity and you don't like what your agent is doing, you send them a notice and say, look, power of attorney I signed on this and this date, I'm revoking it. You no longer have my permission or authority to act on my behalf in any way, and give me the power of attorney document back. Yes? Oh. Pardon?
I thought they wouldn't be using your power of attorney. You still have that capacity.
No, you still, people, for whatever reasons, maybe they start out and they think, I'm going to have this in effect now and I'm going to give it to my son or daughter. They're the agent. There's some things they can take care of for me. But then and some people feel comfortable with that. But what happens is then the agent starts doing things like saying, well, I'm not going to let your brother or sister come visit with you at the assisted facility or the personal care home, or I'll get your mail and I'll decide what you're going to see. And if there are things and you still have your capacity, you could say, you're fired. I'm taking that back. And there could be other reasons people would have an agent in place, even though they still have their capacity. Maybe they feel more comfortable having somebody handle finances. Maybe they're in some kind of a facility where they need a structured environment because of physical demands, but don't want to get out and handle their own affairs. Maybe somebody needs to manage their property for them. You can always fire your agent as long as you have the capacity to do it. But we talked about recording these things a few minutes ago. And if you are going to revoke a power of attorney that has been recorded, then that notice of revocation should also be recorded in the same office where you recorded the power of attorney document. Once your agent receives that notice that the document's been revoked, they don't have any more authority to act on your behalf.
Generally speaking, when they're recorded, is that done by your attorney or do you do that yourself?
Anybody can do it. I frequently, if I think the clients are going to do it and I've recommended that it be recorded, I just tell them where to go. Now in Beaver County, where I spend most of my time, for whatever purpose you want to record the power of attorney, it's done at the Recorder of Deeds office. Depending on the county size, like Allegheny County, it will be different offices for different purposes. I just tell them, you go down there, you take a check for, you know, it costs this much for the first 4 pages and then $2 a page after that. Just go down there, take a check, give it to them, they'll check it over and record it. Anybody can do it. Doesn't have to be the lawyer. It's pretty simple to do it, actually. You just have to have a check or some money to give them to record it for you. Why might you want to change these things? Well, you know, if I did one of these documents when I was 35 or 40 years old, or living will documents, that I don't want any of that stuff, I don't want any life-sustaining medical treatment, you know, now that I'm closer to 60, I might say, well, maybe that's not such a bad idea. You know, maybe I want that stuff. Or, you know, medical advances occur. Just think back, you know, 40 or 50 years and the changes we've seen. Just think back, you know, 5 or 10 years, the changes we've seen in technology and medical technology especially. You know, a diagnosis or a prognosis might become more promising. Maybe the person you named as your agent moved away. So maybe you have to change it. Maybe the person that you named as your agent is your brother that you had a big fight with and haven't talked with in 5 years. Be a good reason to change it. Last thing we're going to talk about, and this will be quickly, are these documents called these out-of-hospital emergency do not resuscitate orders. These things, they're in the packet that you got. That watermark, the SMP, is supposed to be SAMPLE for sample. You can't fill these out yourself. These have got to be done by your physician. And again, what's the purpose of these things? If it's an emergency arises, somebody finds you the paramedics outside of the hospital. The people that carry out the medical instructions are doctors in hospitals and healthcare facilities. The people who come pick you up off the street or take you out of the house, they're paramedics, EMS people. If you have one of these documents in place and they see this, they know, and it's kind of limited, it's not as broad as a living will, but it says, you know, my doctor signed this and I don't want CPR. Your physician has to fill it out, so when they are aware that you have these things, they are permitted, you know, not to revive you with CPR. Now, where do you get these things? How do you get them? Only if you're diagnosed with an end-stage medical condition or if you're permanently unconscious. And you might be thinking, so how do I get one if I'm permanently unconscious? Your agent, under a power of attorney, or your guardian could ask your physician to fill one of these out for you. That's how. And if you're 18 or a high school graduate or married or an emancipated minor, you can get one of these do not resuscitate orders. Yes?
I'm kind of surprised that although there isn't something that enables for religious beliefs someone to also follow do not resuscitate.
Well, in Pennsylvania, that's, you know, what we have says that you've got to qualify with these conditions to have these do not resuscitate orders honored. Yeah. Now, there are occasions, I mean, you could consent to those things, and there's case law in Pennsylvania about religious preferences, even if it's receiving some kind of a treatment, a transplant, blood transfusions. There are appellate court cases about those specific issues, but nothing in the way of legislation. As a matter of fact, if you are taken to a healthcare facility who, for religious reasons, cannot honor the instructions in a living will, and they can't get you to some other facility that will honor them, and you need treatment, they're permitted to keep you there and to treat you and ignore the living will. But they have to make some effort to get you somewhere else.
Yeah, I understand making the effort, but in terms of the religious belief that, once you have passed away, that the body should not then be disturbed. That basic religious belief, right?
Well, once you've passed away,
Right.
then it's time for your family or who you've named as an executor to step in, or well, of course, you can name it. You can tell your agent that they can dispose of your remains or consent to autopsies, but then it's time for, once you die, a power of attorney document and a living will is of no use. I mean, those people, agents under those documents can't act on your behalf except in those 3 limited circumstances once they are aware that you've passed away.
But the resuscitation order is basically, it's a medical intervention that is based upon the body passing away and then bringing it back.
Right. But to get them, you have to have those conditions in place.
So basically, the legislation is inadequate. Is what is it? It is not following.
Well, it's not all-inclusive. Yeah.
I get it. Okay.
So how do you know if you have these things? Well, you get them by asking your doctor. Your doctor can order these forms from the Pennsylvania Department of Health. And you've got a card and kind of a bracelet that looks like an admission bracelet. And if you're wearing one of those, with a lanyard around your neck or wearing the wrist bracelet, that's how EMS folks know that you have one of these documents in place. Can you revoke these? They're probably the easiest of the 3 documents to revoke. You can just rip it up, burn it, put it someplace where nobody's ever going to find it. Or you convey your desire verbally or in writing. Maybe if you've been picked up and somebody, maybe you're going into heart failure and you think you're going to have a heart attack and your heart's going to need to be resuscitated, you could say, that DNR, it's okay to give me CPR. I've changed my mind. Now, anybody can do these documents for themselves. You can't do these documents like a power of attorney for somebody else, because that's the unauthorized practice of law, which is a misdemeanor in Pennsylvania. Although some people do it, I have been told by some notaries that they say, oh yeah, people come down, we fill out those forms for them, we write all the language in, and we notarize them for them. And they really, unless they're lawyers, they really shouldn't be doing that. Notaries are, not people who are permitted to give legal advice unless they happen to be lawyers. Is it a good idea to have a lawyer do these? I think it is. We're not drumming up any business by telling you that, because we don't charge folks. You qualify by income level or being an older adult in Allegheny County. We do the documents. People who practice in this area, who talk about this stuff, it's things they have experience in drafting the documents. This is the kind of stuff they give a lot of thought to and have a lot of experience with in dealing with clients. And I just think it's a good idea to talk to a lawyer who does this stuff to make sure what you want to have done actually takes place. We've already talked about the problems with the do-it-yourself forms. Where do you find somebody? Well, if you have a lawyer you've dealt with, ask him or her. And if your lawyer doesn't feel comfortable doing these kinds of documents, ask your lawyer, who would you recommend? I don't do criminal law and I don't do personal injury law, but if somebody asks me, who would you recommend? I mean, I know people, who do different kinds of law, and I know people I trust who I would send them to. So ask your lawyer. If you can't if you can't do it that way, you're going to have to look in the yellow pages, and I think they still have yellow pages. I mean, I don't know anybody, I guess they're around anymore. I see them being delivered. If I want to look something up, I'm usually on the internet. You'd look under somebody who practices in wills, estates, and trusts, or somebody who holds himself out as practicing elder law. Those are the folks I would recommend. You can also call the Allegheny County Bar Association's lawyer referral service at that number, 261-6161. Tell them what you want. They'll hook you up with somebody that practices in that area, and for $30, you get a 30-minute consultation. If you like what they're telling you, I guess you can, go further with the transaction, tell them that you'd like them to do a document, or if you want to go someplace else. Today's presenting attorney, if we had our volunteer here, they would have information about how to get in touch with them. One of our volunteers has told people, if you call me and want to talk about this stuff and tell me you were at one of the seminars, he said, I'll talk with you for up to an hour on the phone. He said, if you don't like what I'm telling you, that's fine. We hang up, no charge. Go find somebody else. If you like what I'm telling you, come on in and we'll make some arrangements. And I think that's it.
My father spent his last teenage birthday in a ring of fire. I will not die here, he said to himself. 50 years later, he whispered the same thing to me from the hospital bed. My dad, he's always had time for me. There are a lot of memories that we feel lucky to have shared with him. All he wants is a few more moments and a place he loves, surrounded by the people who love him.
Hospice provides the end-of-life care you and your loved ones want and need. It's available to everyone.
With the help of the people at our local hospice, he got his wish. And so did we.
Call a hospice in your community for more information on this service that makes the most of moments with the people you love. Hospice care. Comfort and compassion when it's needed most.
I am Joan Rivers with an important announcement. Getting old is horrible, okay? Horrible.
You're not old. I mean, you're older, but you're not old.
You want to see old?
Oh, God.
Yes. Grow up, for goodness sakes. The last man to hit on me was an undertaker. I know where
I don't want to talk about
Well,
this,
you're going to
Mom.
have to talk about it. It's the future. It's coming right at us. And I'm not worried about dying. It's getting there. I mean, heaven is going to be fabulous. It's going to be a giant shopping mall, and there's going to be 20% off on everything, except for me, 44.
You're doing jokes, and I'm just not ready.
Well, you have to be ready. You have to listen to me. Look, there are things to discuss. They're going to be my needs. They're going to be my wants.
Mom, I don't want to hear this. I just don't want to hear this. La, la, la,
Don't give me la, 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 la,
I
la.
don't. I can't. I can't do
Talk
this.
to your family about aging, even
No.
if they're not ready to listen. Come on, listen to me. Listen to me.
For the first time?
Yes, for the first time.
No matter who you are, it's not easy talking about aging. For help, go to voa.org/talk. A message from Volunteers of America.
Kath, have you heard from Patty and Richard yet?
Patty was going to stop and pick up a pie, and Richard was going to file for Medicare.
Filing for Medicare? We won't eat till midnight tomorrow.
Richard's filing for Medicare online at socialsecurity.gov. It takes less than 10 minutes. Hey.
You made it.
No problemo, Papo. I've got the pie.
And I got my Medicare.
And I've got the turkey.
Did you get that online too?